This is the mast, the boom, the mast track, and the mast foot. Fitting into the mast foot is a universal joint. They call it a universal joint because, unlike you liberals who use joints all the time, this is the only joint that a conservative like myself will ever use. Welcome to Political Windsurfing in Coronado. I designed this Toastmaster topic so that all of you who enjoy my political perspective can hear some interesting facts. For those of you that prefer to learn about windsurfing, you can learn a little about this sport. If you don't like either, well, as we all learned in grade school, multiply two negatives and you get a positive. In other words, if you can't enjoy this, you're just a poor mathematician. As I am windsurfing today, I am trying to decide which Supreme Court decision is the worst. In 1962 and 1963, there were three court cases that removed voluntary prayer and ruled against the reading of the Bible in our public schools. These three cases were Engle via Vitale, Murray versus Curlette, and Abington Township School District via Schimpf. Interestingly enough, the Supreme Court violated close to 200 years of precedent in order to make these decisions. Here is an excerpt from Church of Holy Trinity v. U.S. in 1892. Among other matters, note the following: the form of oath universally prevailing, concluding with an appeal to the Almighty, the custom of opening sessions of all deliberative bodies and most conventions with prayer, the prefatory words of all wills in the name of God, Amen, the laws respecting the observance of the Sabbath, with the general cessation of all secular business, and the closing of courts, legislatures, and other similar public assemblies on that day. These and many other matters which might be noticed add a volume of unofficial declarations to the mass of organic utterances that this is a Christian nation. That's the Supreme Court Justice David Brewer talking in 1892. This is a Christian nation. Imagine that. Unfortunately, his precedent and many others were overruled in 1962 and 1963. What has been the effect of the eradication of God and an absolute moral standard from our public schools? As early as 20 years ago, our public elementary and high schools were ranked #1 in the world. How are we doing today? Students in Shanghai who recently took international exams for the first time outscored every other school system in the world. In the same test, American students ranked 25th in math, 17th in science, and 14th in reading. Now, just because our schools have gone downhill doesn't mean the court is to blame, right? Well, how do private schools that still read the Bible daily do in comparison to public schools? Mean 2014 SAT scores for public school seniors were 492 in reading, 478 in writing, and 501 in math. Meanwhile, students in religious schools scored 533 in reading, 41 points higher, 527 in writing, 49 points higher, and 537 in math, 36 points higher. Wow! This is prima facie evidence that private schools, with their heavy influence on biblical teaching, is also doing a better job of educating our children. Private schools are safer with less violence, and they teach high moral standards in addition to higher scholastic standards. Perhaps our students would be better off if the Supreme Court justices had maintained our status as a Christian nation. But right now I am thinking that perhaps Roe versus Wade, decided in 1973, and its reaffirmation in Planned Parenthood versus Casey in 1992, are even worse decisions. These court cases found that a woman has a right to end her pregnancy through abortion at any time up to viability of the fetus, which is now considered to be around 26 weeks into the pregnancy. Here are some facts about abortions. Some 1.06 million abortions were performed in America in 2011. Women who have never been married account for 1/3 of abortions in America. Blacks comprise only 13% of the population of America, but account for 37% of all abortions. Black women are 5 times more likely to abort than white women. Where is the outrage? Where is the National Association for the Advancement of Colored People? As an aside, the NAACP is doing their best to stop capital punishment in this country because they claim black death row inmates are more likely to be executed than white death row inmates. Importantly, most reasonable people believe there is a significant moral difference between the state executing convicted killers for the reasons of deterrence, self-defense, and justice versus the mass abortion of innocent unborn babies. But even if you thought these actions were morally equivalent, there are about 1,200 convicted black murderers on death row and about 370,000 abortions of black babies every year. In the name of ideological consistency, shouldn't the black community be at least 300 times more outraged about black abortion as they are about the death penalty? I ask again, where is the outrage? 69% of pregnancies among blacks are unintended, while that number is 54% among Hispanics and 40% among whites. About 21% of all pregnancies end in abortion, and about half of all unintended pregnancies. Only 2 to 3% of unintended pregnancies end in adoption. Less than 1% of all abortions take place because of rape or incest. Only 3% of abortions are due to possible health problems with the baby. The primary 3 reasons for abortion as reported by women are 21% inadequate finances, 21% not ready for responsibility, 16% the woman's life would be changed too much. Philosophically, reasonable people have different ideas of when a soul enters into an unborn child. Catholics and Christians believe it happens at conception. Atheists believe nobody has a soul. Agnostics either do not know or do not care. As previously mentioned, half of all unwanted pregnancies end in the death of the unborn child, and only 2% of black unmarried women and 3% of white unmarried women pregnancies end in adoption. However, there are over 1.5 million anxiously awaiting heterosexual couples who would love to adopt a child. Now, the 3 primary reasons indicated above by women who abort their children all revolve around the difficulties of raising a child. So wouldn't the best option be to encourage adoptions rather than abortions? Seems like a winner across the entire political spectrum. Instead, we have over 1 million unborn, innocent U.S. citizens and potential taxpayers aborted each year. This is how I feel about that. When the winds of political expediency are gusting against us and the fickle tide of popular opinion is ebbing and flowing, it is not unusual to lose our balance, drop our sail, and grunt with pain. In the face of failure, many who are tested give up. Others with more heart pick up their sail and continue to fight upwind. Unfortunately, we have yet another Supreme Court disaster to discuss. In Bowers v. Hardwick in 1986, the majority of the Supreme Court upheld a Texas statute outlawing sodomy. In 1986, laws against homosexual conduct were considered constitutional. That is right, constitutional. In 1996, Congress passed by veto-proof majorities the Defense of Marriage Act that barred same-sex married couples from being recognized as spouses for purposes of federal laws that subsidized marriage. Republicans, Democrats, and a supermajority of the country favored this legislation. President Clinton signed it into law in September 1996. This law codified non-recognition of same-sex marriage for all federal purposes, including insurance benefits for government employees, Social Security survivor benefits, immigration, bankruptcy, and the filing of joint tax returns. However, in Lawrence v. Texas, decided in 2003, Justice Anthony Kennedy decided to override these previous legislative and judicial decisions and ruled that a newly amplified right to privacy derived from the Due Process Clause of the 14th Amendment now disqualified laws against homosexuality. Starting in 2003, Mr. Kennedy, a Catholic in name only, joined with other liberal members of the court to extend previously unfound constitutional protection to homosexuality. Following this trend line, in United States v. Windsor in 2013, the U.S. Supreme Court ruled the Defense of Marriage Act unconstitutional under the Due Process Clause of the Fifth Amendment. To complete this emasculation of our moral code, in Obergefell v. Hodges in 2015, Justice Kennedy was the swing vote for finding a fundamental right for homosexuals to marry under the Due Process Clause and Equal Protection Clause of the 14th Amendment. Do you notice how many times certain Supreme Court justices invoke the due process language when they can't find anything actually specific to their prejudices written in plain language in the Constitution? This due process ruse is a catch-all umbrella to justify anything that a liberal majority of the court decides. Unfortunately, it trumpets the end of judicial restraint and the trampling of the rights of our citizens to make our own laws. The Supreme Court defied the will of the country when it sabotaged the Defense of Marriage Act, and it defied the history of our nation and of civilization itself when it redefined marriage. As Chief Justice Roberts pointed out, the same language justifying homosexual marriage can also be extended to justify incest, bigamy, and polygamy. I hate to see what other poor things are going to happen to Amy. I know it is a poor joke. Not too long ago, homosexual marriage was simply a poor joke, instead of a newly discovered, constitutionally protected civil right.
No. There we go.
To recap, the liberal Supreme Court justices abandoned an absolute moral standard when they defied precedent and tradition and eradicated voluntary prayer and the Bible from our public schools. The standards of scholastic achievement have since fallen. Having decided to abandon an absolute moral standard, that the soul enters the unborn child at conception, this liberal majority was free to embrace a moral relativism that stated life should only be protected at the stage of viability, about 26 weeks into a pregnancy. This callous disregard of the life of the unborn child is mirrored in the decision of many women who are 25 times more likely to abort their children rather than put them up for adoption. Finally, the liberal members of the court decided that the foundation of our nation and its tax advantages that reward child rearing and a normal traditional marriage were somehow hurtful and unconstitutional. To do this, they had to override the will of the people as codified in the Defense of Marriage Act and invent due process language that can be used as a precedent for even more damaging unconstitutional judicial activism. So how do we fix this? The conservative members of the court are inclined to respect conservative and liberal precedent under the doctrine of judicial restraint. The liberal members of the court insist on judicial restraint to protect their victories and resort to judicial activism when overriding previous conservative victories. The net effect is that the laws of our land are being ratcheted to the left. Our laws are directed towards justifying an increasingly immoral, progressive, Leviathan welfare state. As the federal government gets larger and more powerful, as the mediating institutions of the church, the family, and of marriage are attacked and weakened, we all suffer a great loss in individual liberty and autonomy. As I have pointed out, the Supreme Court seems to veer into whatever a majority of the court feels is currently politically correct. These liberal justices disregard centuries of previous court precedent when the mood seizes them. Unfortunately, the same lack of judicial restraint that produced this mess is the same process we will need to embrace in order to fix it. The only realistic answer is to pack the court with more dependable conservatives like Justices Roberts, Scalia, Thomas, and Alito. We have to elect strong conservatives to the presidency and then push them to appoint more conservative champions in the mold of Justices Roberts, Scalia, Thomas, and Alito. When the Supreme Court is more receptive and we have built a consensus for change, we can advance the constitutional amendments necessary to correct these mistaken court cases. That is our game plan. That is our challenge. It is not a courageous or noble act to blow with the winds of political expediency. It is courageous to fight for what is right, against the tide of fickle public opinion. It is time to take our country back, pick up our sail, and stand up for God, our unborn children, and for traditional marriage. It is our only hope for fixing this abrupt moral slide. Let the sailing begin.